Hello everyone, and thank you for joining my PIP Monthly August 2020. My name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our August 2020 topics include 3 Court of Appeals cases that were issued in August, and trending topics in PIP litigation, in which we will discuss employee versus independent contractor relationships and the No-Fault Act. As for our case law update, the first case I wanted to discuss is Loyola v. Citizens Insurance Company of America, issued August 6, 2020. Duckworth v. Cherokee Insurance Company, issued August 6, 2020. And Glasker Davis v. Demand Stephen Alvenshine and Mimic Insurance Company, issued August 13, 2020. First up for our case law update is Loyola v. Citizens Insurance Company of America, issued August 6, 2020. Loyola is important because it narrows the definition of an allowable expense. It provides necessary guidance into what is deemed to be an ordinary allowable expense under the No-Fault Act. When analyzing whether something is an allowable expense, the courts generally will look to whether a fact finder can easily identify which costs are of a new character and are thus for the injured person's care, recovery, or rehabilitation, and which costs are ordinary, everyday expenses that are unchanged after the accident. Determining this typically assists insurance companies in combating any non-traditional expenses. This issue typically pops up when an insured or plaintiff is attempting to claim benefits that are out of the ordinary. The courts must decide if this is something the carrier should pay for, or if this is something that's an everyday expense that this person should be paying for and has nothing to do with the accident or injuries that resulted from the accident. In its analysis on appeal, the court emphasized that a claimant seeking allowable expenses under the No-Fault Act must satisfy the requirements of 2 statutes, MCL 500-3105 Section 1 and MCL 500-3107 Section 1 subsection A. Essentially, what the court is trying to do is determine which products are ordinary and everyday products, and which products or accommodations or services are due to the accident or can be related back to the accident. Insurers do not have to pay for ordinary everyday products and services or accommodations just because those accommodations or products or services are being claimed after the accident. They must be related back to the accident itself. This concept is delved more deeply into in the Admire v. Auto Owners Insurance Company case. The court in Loyola analyzed each expense claimed by the plaintiff and used the Admire case to focus on whether the expenses were combined or integrated. The Supreme Court in Admire explained that special accommodations or modifications are always compensable, but whether an ordinary item itself is compensable depends on whether the accommodation or modification can be easily separated, both conceptually and physically, so that the fact finder can identify which costs are of a new character and are thus for the injured person's care, recovery, or rehabilitation, and which costs are ordinary everyday expenses that are just unchanged after the accident. Again, the court decided to put accommodations or services into 2 categories, combined or integrated. A combined product or accommodation results from an ordinary expense unchanged as a result of the injury being joined with an accommodation or product that is actually for the injured person's care, recovery, or rehabilitation. An integrated product or accommodation involves the blending of an ordinary expense with one that is for the injured person's care, recovery, or rehabilitation in a way that the resulting product or accommodation cannot be separated easily into unit costs. Ultimately, in Loyola, the Court of Appeals held that food stipends, wages, and personal trainer charges were not an allowable expense as a matter of law, and the defendant should have been allowed to submit jury instructions to that effect. Next up in our case law update is the Court of Appeals unpublished opinion, Duckworth v. Cherokee Insurance Company. Duckworth provided guidance on the 2-step analysis for determining the employee/independent contractor distinction. In Duckworth, the plaintiff drove a truck for Speedway Express and was injured in a motor vehicle accident. If the plaintiff was an employee, Cherokee Insurance Company would be first in priority. If the plaintiff was an independent contractor, Progressive, his personal no-fault carrier, was first in priority. Our trending topic in PIP litigation that we're going to discuss today is the employee/independent contractor distinction and its application to the No-Fault Act. I'm going to go more deeply into that a little bit later, but this decision did come down August 6, 2020, so it warranted a discussion in the case law update section of this month's My PIP Monthly. So in Duckworth, the Court of Appeals reversed the trial court's summary ruling that plaintiff was an independent contractor and then further explained how to make this determination. First, a trial court must apply the economic reality test when evaluating whether an injured person was an employee or an independent contractor for purposes of the No-Fault Act. Again, this distinction is incredibly important because determining priority of an independent contractor or employee determines what carrier will pay. Just like the decision in Duckworth and the plaintiff in Duckworth, this is typically seen in situations of truck drivers, and transportation companies. So first, the court must apply the economic reality test. Second, if the injured party is deemed to be an independent contractor under the economic reality test, then the next inquiry is whether the injured party was self-employed or whether he was acting on behalf of his business at the time of the motor vehicle accident. If the answer to that question is yes, the worker is an employee and is entitled to benefits from the insurer of the truck. If the answer to that is no, then it is likely the employee or the injured party is entitled to benefits from their own personal auto insurance policy. In Duckworth, the court discussed 8 factors that should be used to determine whether a worker is an employee or an independent contractor. The factors include: what liability does the employer incur in the event of an at-will termination? Is the work being performed an integral part of the employer's business, which contributes to the accomplishment of a common objective? Is the job one where the worker primarily depends on wages to pay his living expenses? Does the employee furnish his own equipment or materials? Does the worker hold himself out to the public as being able to perform this work? And is the work customarily performed by an individual, such as an independent contractor? So all of these factors help the court determine if there's control over the worker. The court also looks at payment of wages, maintenance and discipline, and the right to engage or discharge employees. The last case I wanted to discuss for our case law update is Thomasina Glasker Davis v. Damon Stephen Alvenshine and Mimic Insurance Company. This opinion was issued August 13th, 2020. I thought this case was important. The issue that we're going to discuss here is definitely one we need to keep our eyes on and is possibly going to become a hot topic for plaintiffs' attorneys when they're attempting to combat fraud defenses. A few takeaways from Glasker Davis. Affirmative defenses must be pled with specificity, and this goes for all cases, but especially fraud cases, because what we're seeing is the courts are attempting to narrow the defenses with regard to fraudulent conduct of plaintiffs. Generally speaking, in most affirmative defenses, we allege fraud at the onset of litigation. However, what this case is changing is that the court is requesting defendants be more specific in their affirmative defenses. So once information regarding fraud is obtained or narrowed, that must be reflected in the affirmative defenses. And failure to do this may preclude a defendant from raising the issue on a motion for summary disposition. In Glasker Davis, plaintiff claimed entitlement to household replacement service benefits daily from July 2016 until September 2017. Plaintiff supported this claim by producing household service statements prepared by her daughter. At plaintiff's deposition, she testified that she relied upon her daughter to keep track of these services that were performed, and that her daughter usually assisted her 3 times a week in 2016 and 2 times a week in 2017. MEMIC Insurance Company then moved for summary disposition on the basis of the fraud provision in its policy, which stated that the entire policy is void if any insured person has intentionally concealed or misrepresented any material fact or circumstances relating to any claim made under it. The court then granted summary disposition in MEMIC's favor, and on appeal, plaintiff argued that the general affirmative defenses filed by MEMIC did not provide plaintiff with sufficient notice that fraud would be relied upon to defend the claim. The Court of Appeals noted that while Michigan is a judicial notice pleading jurisdiction, which has a relatively low bar for the sufficiency of initial allegations, especially when discovery has yet to be conducted, the function of a pleading in Michigan is to give notice of the nature of the claim or defense sufficient to permit the opposing party to take a responsive position. And obviously, it's not possible to plead every conceivable defense at the initiation of a case, so the court said that affirmative defenses may be amended to conform to the evidence. The court went on to cite Baker v. Marshall, holding that a defense premised on the violation of an anti-fraud provision in an insurance policy constitute an affirmative fraud defense, which must be stated with particularity pursuant to MCR 2.112b2. Therefore, MEMIC's affirmative defenses were found to be vague, stating only that plaintiff failed to provide information at an unidentified time, or that the information was incorrect and inconsistent in an unidentified way. The court held that that was an insufficient affirmative defense and did not put plaintiff on notice of defendant MEMIC's reliance on the fraudulent conduct. As MEMIC did not amend its affirmative defense once details of plaintiff's fraudulent claims or conduct were discovered, the affirmative defense was not pled with specificity, and summary disposition in favor of the defendant was then reversed. An important takeaway from Glasker-Davis is that defendants should simply move to amend its affirmative defense once that information regarding fraud has been discovered. As for our trending topics in PIP litigation, again, I wanted to discuss the employee, the independent contractor distinction, and its application to PIP benefits. Under MCL 500-3114, Section 3, the priority question of whether a worker is an employee or independent contractor is crucial. This distinction is often seen with drivers for trucking and transportation companies. Questions of priority between potential insurers has always been governed by MCL 500-3114, and as a general rule, it notes that except as provided in subsections 2, 3, and 5, personal protection insurance policy described in Section 3101, Section 1 applies to accidental bodily injury to the person named in the policy, that person's spouse, and a relative domiciled in the same household if the injury arises from a motor vehicle accident. Put simply, a person is to generally look to his or her own personal insurance unless one of the exceptions found in subsections 2, 3, or 5 apply. Our main focus here is going to be on subsection 3, which determines the priority of an employee or independent contractor. Subsection 3 notes that an employee, his or her spouse, or relative domiciled in the same household who suffers an injury while the occupant of a motor vehicle owned or registered by the employer shall receive PIP benefits of which the employee is entitled to from the insurer of the furnished vehicle. Put simply, the employee will receive PIP benefits when injured from their employer, who typically owns the vehicle. If the driver is an employee, the no-fault carrier for the trucking company is first in line to pay for PIP benefits. If the driver is an independent contractor, then that driver's own personal no-fault carrier becomes first in priority to pay for benefits. And as we noted earlier in the Duckworth case, courts applied the economic reality test to help decide that worker's classification. Those factors to be considered include control of the worker's duty, payment of wages, right to hire, fire, and discipline, and the performance of duties as an integral part of the employer's business towards the accomplishment of a common goal. The Algonac v. Harco National Insurance Company case applies the economic reality test, but it's also important to note that under the test, no weight is given to whether a contract refers to a person as an independent contractor or employee. You must look to those factors in the economic reality test to determine if that person is indeed an employee or an independent contractor. It does not matter what that person calls themselves or if there are documents that say that a person is an employee or independent contractor. Although it's still important to pay attention to those documents, that is not the only deciding factor. The court in Algonac applied the economic reality test. Plaintiff in that matter had contracted with a transportation company to haul cargo. He was under the transportation's dispatch at the time and he was involved in an accident. Plaintiff sought coverage for PIP benefits from the insurers of his own personal vehicles, and the Court of Appeals was tasked in determining whether the plaintiff was an employee or independent contractor. The court looked to whether plaintiff could refuse loads offered by his employer. They also looked to see whether the plaintiff was issued 1099 forms, whether either party was free to terminate the relationship at any time, and whether the company hired other drivers as well. After analyzing these factors, the court determined that the plaintiff in this case was entitled to PIP benefits from his own personal carrier and not the insurer of the truck. Some takeaways from today's My PIP Monthly are food stipends, wages, and personal trainer charges are typically not allowable expenses. The Duckworth factors. Duckworth added some factors to the economic reality test that we talked about previously and somewhat narrows the economic reality test to help insurers determine who is first in priority with regard to payment of PIP benefits for a driver or trucker when he or she gets into a motor vehicle accident. Also, remember to amend affirmative defenses if information regarding fraud has been determined. Also, if a driver is an employee, the no-fault carrier for the trucking company is first in priority to pay PIP benefits. If the driver is an independent contractor, the driver's own personal no-fault carrier is first in priority. And the courts apply the economic reality test to help determine this classification. Again, thank you for attending August 2020's My PIP Monthly. My name is Amber Rouse Holloway, and I'm a partner here at the Troy office of Secrets Wardle.